All right. We are in business. Okay. So, first things first, last time we met, I went through the first 2 pages of the agreement, all of these, additional disclosures that kind of come with the contract, et cetera, et cetera. And if you have questions, by the way, drop them in the chat or unmute yourself. So we got through, the agency, we got through the disclosure regarding real estate relationships and the consent to represent more than one buyer or seller. What we skipped that time is this form right here, which is a brand new form. They just released it on Friday, I believe. And it's the Fair Housing and Discrimination Advisory. And a lot of great information here. It's an advisory. We talked last time about being, having disclosures and agreements and waivers and amendments, addendums, and this is an advisory. This is basically giving advice to people. Well, who are the people that are getting this advice? Well, us as agents, our buyers, our sellers. And basically what this is it's just talking about discrimination against anybody, I would say, but especially those in the protected classes, is not allowed. And this is federal and state laws. We talk about the Federal Fair Housing Act, California Fair Employment Housing Act, the California Unruh Civil Rights Act, the Americans with Disabilities Act, and any other fair housing laws that might apply. And so what you got here right in the middle is a matrix of all the different protected classes or statuses: race, color, ancestry, national origin, religion, sex, sexual orientation, gender identity, gender expression, marital status, familial or family status, source of income, such as Section 8, disability, medical condition, citizenship, primary language, immigration status, military or veteran status, age, criminal history that is non-relevant convictions, and
Baby, can you give me my pink thing, baby? That pink stand right there, please.
Okay, so all that is not allowed, right? All that discrimination is not allowed, obviously. We should all know that. And so it's prohibited. And we're going to have all your clients sign this. This is required for our files. It's attached to the purchase agreement. It's attached to the listing agreement. It's attached to lease agreements. It's attached to the buyer representation agreement. So you're going to get this automatically, okay? Guys, pull the form up and read through it. I'm going to point out a couple of things. I mean, obviously it applies to our sellers. It applies to landlords. It applies to real estate brokerages, real estate licensees. That's all of you as agents, property managers, etc. Okay. And I just wanted to show you paragraph 8 really quickly here. Examples of conduct that may not be motivated by discriminatory intent, but could have a discriminatory effect. And look at this. Number 8A right here, prior to acceptance of an offer, asking for or offering buyer personal information or letters from the buyer, okay? You guys have been used to probably writing buyer love letters to the sellers and telling them how great your clients are, please take our offer. And I've talked to a few people who've said, gosh, I've gotten offers accepted because of that. And it makes me think immediately, well, how many offers maybe you haven't got accepted because of these letters? So this is an example of something that could be discriminatory, even though it's not intended to be so. And here's how. Buyer submits one of these letters, seller reads one and says, oh, I really like these people. They have a family. I'm going to sell to them. Well, remember, familial status is a protected class, meaning you cannot discriminate somebody's offer or not take an offer because somebody doesn't have a family, right? So basically, it says here, these documents may inadvertently reveal or be perceived as revealing protected status information, especially ones that have photos or giving intimate details about the people, that gives the seller a chance to maybe not pick their offer for whatever reason. And what the problem is, whatever that reason is, may be discrimination, okay? So for sure, on your listings, you should not be having your seller review these letters to decide which offer they're going to take. Okay. And it actually says here, prior to acceptance of an offer, asking for or offering buyer personal information. So the word offering kind of implies that on the buyer side, we shouldn't be writing these letters at all. So my perspective is, if you have any sort of inclination to put an offer together, it basically just should be reflecting all of the financial merits of the offer and the ability to close, right? So that's about it, but no other personal information should be disclosed on that. Okay. There's a whole bunch of other, examples of, not intended, but could be discrimination, actual discrimination against protected classes. And there's some examples of more positive or best practices. And then you got your fair housing resources, websites you can go to find out more information. And there's a couple limited exceptions, but probably you're not going to be, using any of these exceptions. So with that said, this is now, again, attached to the purchase agreement, brand new form. It's called the FHDA, Fair Housing and Discrimination Advisory. So just want to start off and, let you know about that brand new form that's now with your contracts. All right. So 2 weeks ago, we went through the first 2 pages of the purchase agreement, and we got all the way to, the first 3 actually, and we got all the way to the bottom here, and we ended right before paragraph 9. So let's go ahead and pick up right there. Closing and possession. So the default for the RPA, residential purchase agreement, is that the buyer intends to occupy the property as the buyer's primary residence. If that's not the case, there's a checkbox there. B, seller occupied or vacant. The default here is that possession will be delivered to the buyer at 6 p.m. On the date of close of escrow. That's the default. Or you can change the time, or you can change when that possession is delivered. You can see on my sample here, I've got the box checked for no later than 3 days after close of escrow at 6 p.m. Okay, because that's the default. So that would be an example of the seller staying in possession. Well, if the seller stays in possession, right? Look, there's a whole paragraph for that. Seller remaining in possession after close. And it says that the seller is going to stay, whether it's for a few hours, a day, or many days or months, then we need to use another form, okay? Just checking the box and putting 3 days after close is not good enough, guys and gals. I want you all to remember that Nick said there's probably a form for that. Anytime you think like, oh, I need to put some language together for X, Y, and Z, just remember Nick said there's probably a form for that. So for here, the seller is remaining in possession. Well, we have a form called the SIP. What does that stand for? Seller in possession, okay? The SIP form is if there's going to be a rent back for less than 30 days, okay? And, maybe you give it for free, maybe you charge some rent or whatever. You still are going to use that SIP form. There is a place to put in how much you're getting that option to stay is and a potential deposit. Now, if it's more than 30 days, we have another form right here, the RLAS, residential lease after sale. Okay, so that's going to be your full-blown lease agreement. And it's, 5-7 pages, something like that, with all the other forms attached to it. Okay. Now, a couple things to think about. I'll tell you this right now. With all the eviction moratoriums and COVID-related tenant protections and state and county and city tenant protections, once you have a seller in possession, the buyer, the new owner, now has a tenant in the property. And the only way you can get that person out if they refuse to leave is through an eviction. So I will tell you, if there's any form of a seller in possession after the fact, I recommend that you put money in escrow. You put money in escrow and leave it there. So you have some sort of insurance that if indeed the seller refuses to move out, which we've seen happen numerous times, then the buyer has some sort of financial recourse. So maybe you say, seller to leave $5,000 in escrow to be refunded if it's a 14-day rent back on day 14, unless seller doesn't leave. If seller doesn't leave, that money goes to the buyer automatically, right? So then you got some skin in the game to get the seller out of the property, or you can renegotiate some terms or whatever. but I've definitely seen it to where people don't leave, even when it's only 3 days or they're buying another property, right? And I just got to keep going back to when you're writing your offers, think about what's going on. Where does the buyer live now? Can they stay in their rental for a little bit longer? Can they move in with some parents? What if things go haywire and the seller doesn't move out for a week or 2 weeks afterwards? So you need to decide, okay, do I need to put a lease back? How long? How much time does my buyer need? Do they have somewhere to go? What are the numbers looking like? What is the seller trying to do? When can everybody move? Right? Many times we see that, the possession is supposed to be on the day of close of escrow, and yet the seller has a concurrent closing to buy another property. Well, there's no way they're going to leave on the day of close of escrow if they don't even get keys till the next day. So you're already 1 day late, and that's if they can move in 1 day, right? So be thoughtful about this stuff. You don't want to have to deal with this at the last minute. You want to be thinking about this when you're writing the offer, okay? So that's seller remaining in possession after close of escrow. Now, paragraph D is here, tenant occupied property. So the default in the contract is that the property will be vacant at least 5 days prior to close, unless otherwise agreed. And if you notice here in big bold letters, note to seller, if you're unable to deliver property vacant in accordance with rent control and other applicable law, you may be in breach of this agreement. So they're telling you up front that if you can't get this place vacant and you have entered into a contract and the time frames are not favorable, you could be in breach, and breach means there could be damages, okay? So what does that mean? Well, let's say you have a tenant in there and a buyer makes an offer and says, we want the property delivered vacant, but you put a 30-day escrow. Well, first of all, how much notice do you have to give a tenant to vacate? Well, if you're in escrow, you can do a 30-day notice to vacate, right? But look at this. It says property to be delivered 5 days before close of escrow vacant. So that means automatically you're at 35 days, okay? Now, I also know most landlords aren't going to just give their tenant notice on the day they open escrow, right? They're probably not going to give notice until most of the contingencies or all the contingencies are removed. That's anywhere from 17 to 21 days. So if you think about that, well, let's take 21 days plus 30 days for the notice, plus 5 days to be vacant, right? Now we're at 56 days for escrow. So again, have some foresight. You got to be thoughtful about this and think, like, what am I doing here? And what are all the timeframes that need to be considered when you draft up this offer, okay? So if the tenant is going to stay, there is another form, the TIP, tenant in possession, another one-pager that you will add to the contract to declare, things about like the deposit and rents and blah, 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 okay? All right, and we'll look at those in another class as well. E just talks about assigning any warranties that the seller may have that is assignable. And then F talks about possession for things like, keys, passwords, codes, means to operate locks, mailboxes, security systems, alarms, home automation, right? Is a Ring doorbell a part of the home automation? Is it attached to the property? I think the answer is yes. It should be included, okay? Now, are they going to keep their account? You don't just transfer the account for the blink. You sign up for a new one, obviously, right? Condos, anything that is required from the condominium. And it also makes a mention here that if it's a condo, the buyer may be required to pay a deposit to get keys to common areas and things like that, which is very common. And I've seen some pretty high ones, a couple $100 to get a key. So consider that. So paragraph 10 talks about disclosures. So what do we got here? Well, the first paragraph, A1, talks about the statutory, meaning civil code required disclosures. And it says the seller will provide things like lead-based paint hazards. They will provide things like a transfer disclosure statement if required. That may not be required. Natural hazards disclosure statement. And then it talks about a few of the basic minimum requirements on a civil code basis. The release of an illegal controlled substance on the property. Notice of special tax or assessments. Notices of mellow ruse. Notice of the 1915 Bond Act or improvements. And if the seller has knowledge of industrial use and military ordnance or military, weapon storage locations. So all those are required to be delivered per civil code. How do you deliver those disclosures? Well, they're in the seller's property questionnaire or the ESD, the exempt seller disclosure. Okay. Now, paragraph 10A2, and by the way, let me just back up to the title: statutory and other disclosures and cancellation rights. What that means is all the things we just looked at have cancellation rights attached to them. Okay. And that is important when we consider paragraph 10A2 here. So it says it says a disclosure is considered complete if the seller has answered all questions, okay, and they've completed and signed the seller sections, and the seller's agent, the listing agent, has completed and signed the seller's brokerage section of the TDS or their agent visual inspection disclosure, okay? So what did we just say there? Well, what we said is the TDS is not considered complete if you, as the listing agent, don't fill in your part on page 3 or provide your AVID. So let's put some context around that. You're in escrow. You give all the disclosures in the TDS, but you haven't done your AVID, which I know happens because I check some of your files and the AVID doesn't come until a few days before close of escrow. And then what could happen? You provide your AVID on the day before close. Even if all the contingencies are removed, the buyer could cancel escrow and get their deposit back. Why? Because the TDS is not considered complete without your portion of it done. Okay, that should be a big wake up and a kind of a warning for all of you guys. Your AVIDs need to be delivered with the TDS for your listings. They're supposed to come with them, and that's supposed to happen within 7 days of opening escrow. So when should you do your agent visual inspection? You should be doing them when you take the listing probably, or when you go get the offer signed when they're getting ready to open escrow, but sometime within the 7 days when you're supposed to deliver to the buyer all of the disclosures, okay? Now, it doesn't say anything about the buyer side having to do their AVID or page 3 of the TDS to be considered a complete disclosure because the seller is the one disclosing to the buyer, okay? So with that said, does that mean you can, not turn in your buyer side AVIDs till the day before close? Of course not. Get those done as soon as possible. I typically do mine when I'm at the physical inspection, okay? All right. Number 3, note to buyer and seller. Actually, let me see here. Yep, we're good. So note to buyer and seller, waiving of these disclosures is prohibited by law. Okay, so the lead-based paint, and then all the questions on the either the SPQ or the exempt seller disclosure. Okay. Paragraph 4 says that within the time specified in paragraph 14, which is the 7 days, seller, unless exempt from providing a TDS, will complete and give to the buyer an SPQ, the seller property questionnaire. So here's the basic rule. If you are required to do a TDS, you are required to do a seller property questionnaire. If you're exempt from the TDS, then you use the exempt seller disclosure, the ESD. So typical examples, probate, certain trusts are exempt from the transfer disclosure statement. That doesn't mean they're exempt from everything. They still have to give an ESD. So it's one or the other. It's either the exempt seller disclosure or the TDS and the SPQ. And, think about it this way. You guys need to have a script around presenting disclosures to your sellers. Our legal counsel basically said you should say that to your seller, these docs are your shield protecting you from being sued, right? You have to disclose everything. And guess what? Mr. Seller, you don't have insurance like I do, which means you'll be coming out of pocket to defend yourself and possibly being on the hook for attorney's fees. So please take these documents extremely seriously. That's how you set up the conversation around disclosures. And my rule is if you call me and ask, should we be disclosing XYZ? The answer is always going to be yes. So the rule of thumb is if you have to ask, the answer is yes about whether something should be disclosed or not. And that's including your knowledge, right? You guys as agents are required to disclose any material facts and defects as well. Okay. Okay, let's see. There's a contract here that paragraph says the buyer will return copies of all the disclosures within the applicable time, which is 17 days. And any new disclosure must be delivered to the buyers. So if a seller or a listing agent or a buyer's agent, but really a seller or seller's brokerage becomes aware of any new adverse conditions that affect the property or any inaccuracies in the disclosures, the seller needs to amend the disclosure, okay? And paragraph 7 actually provides additional time for the buyer to have cancellation. So if something happens after all the contingencies are removed and the seller finds out some new disclosure or the buyer finds out some new disclosure somehow, the buyer will have 5 additional days, assuming that disclosure was done over email or provided over email, 5 additional days to deliver a written notice of cancellation. So basically, if new information comes in at the end of the game here, the buyer will still have the ability to cancel if they feel it's appropriate. Okay. Paragraph B writes in here that natural hazards disclosure report and booklets will be provided within the 7 days. NHD looks at things like special flood hazards, earthquake, high fire severity zones, which obviously we're dealing with quite a bit right now, earthquake and seismic hazards, et cetera, et cetera. Okay. So, you're probably going to be in some zone. We see a lot of seismic hazards for liquefaction. Sometimes we'll see an earthquake fault zone, things like that. More disclosures. Withholding taxes. Withholding taxes. Whenever you sell a property, you have to pay taxes unless you have some sort of an exemption, right? Like a husband and wife selling their principal residence have an exemption to withhold any tax or to pay any taxes up to $500,000. There are instances when the seller will have to pay taxes. And usually if they have to pay taxes, or in many cases, they may have to withhold a certain amount of tax. What that means is when they close escrow holds back a certain amount of those taxes and sends them to the appropriate agency, either the IRS or the state franchise tax board. Okay. So where do we see this? Well, if a seller is selling an investment property outright, no 1031 exchanges, and they're not an LLC or a corporation, they will have to withhold taxes on a state level. It's like 3 1/3% of the price of the property. On the federal level, if a foreign entity or foreign natural person is selling a piece of property, they have to also withhold taxes on a federal level, which I believe is 10%. Okay. So withholding, and why is this in the contract? Well, because it's the buyer's responsibility. Ultimately, it's the buyer's responsibility. So what could happen? Well, let's say you have a foreign seller, they sell their property and they skip town, or they never were in town in the US, right? And they just sell and they collect all their money and they never pay their taxes. Well, guess who gets the bill? The buyer. The buyer is going to get the bill, okay? So in disclosures, when we go through the disclosures, I'll talk more about withholding taxes, but the way we know whether this needs to be done or not is by the seller completing an affidavit about their status as either being non-foreign or having an exemption to withhold on a state level, okay? So you'll see that either on a car form or sometimes through escrow with what we call a qualified substitute. Paragraph D talks about Megan's Law, which is for public sex offenders. All it says is that we need to make available to them the website where they can go to research their neighborhood. That's there. Also, Notice of gas and hazardous liquid transmission pipelines. It's just telling buyers that there may be pipelines under their house. And if they're concerned about that, they can go to this website and get a map to see whether their home is affected. Why would that matter? Well, what if they want to put a pool in or do some other sort of construction where they have to dig a basement or something? Well, if there was a gas line under the house or under the backyard, that would be a problem. So we should be looking at those websites if needed, okay? All right, I bet you guys probably, a lot of you have never even heard of that stuff, right? This is all right here in our purchase agreement, which is why I'm so glad you're joining me here today. Paragraph F talks about condo and planned unit disclosures. So the seller has 7 days after acceptance to disclose to the buyer whether the property is a condo or if it's located in a planned unit development. Usually we know this up front, but technically the seller has a week to tell us whether or not this is a condo or any sort of planned unit development. Additionally, if it is a condo, the seller will have 3 days after acceptance to request from the HOA everything relevant that are, number one, required by law. Number two, disclosure of any pending or anticipated claims or litigation by or against the HOA. Number three, a statement containing the location of parking and storage. Number four is copies of the most recent 12 months HOA minutes for any meetings that have occurred. 5, the names and contact information of all the HOAs governing the property. Sometimes you have more than one. 6, whether there's a private transfer fee. Sometimes some communities will have a transfer fee that in, a couple pages up here, we would decide who would pay for those fees, but we need to know about that because it could affect the sale of the property, right? I know a building in Long Beach has a pretty high, like 1% one, which is like, could be as much as $4,000 or $5,000, okay, for a transfer fee. 7, whether there's any pet restrictions. 8, smoking restrictions. And that's the gist of it. That's the majority of it right there, okay? These usually cost money to order all these things. So the last sentence says, the party, as specified in paragraph 7, which is usually the seller, shall put funds into escrow to pay for all the HOA docs, okay? So this is important, guys. The seller is typically required to order all this information. Sometimes they have escrow do it, and they have to pay for it. Now, in many of your escrow instructions, there's a paragraph that says if escrow needs to pay for anything up front, like HOA documents, their instructions state that they'll take the money out of the buyer's deposit to pay for it and then refund it after the fact when escrow closes and balance things out. Well, what if the deal falls apart, right? In escrow's verbiage, it says they will not be responsible to go collect any funds from the seller to give back to the buyer. So when you see that kind of stuff in your escrow instructions, what I recommend is cross it out. Cross it out and have your buyer initial and say, no, seller needs to bring those funds in. Do not take any money out of our deposit. By the way, when I look at escrow instructions and I see a cancellation fee, I cross that out as well. I don't agree to cancellation fees. Do you guys charge cancellation fees? No. Does title? Do inspectors? Right? Nobody does. Why should escrow? Right? So just another junk fee in there. So you don't have to agree to that stuff. All right, let's keep moving here. Getting into some good stuff now. 11, condition of the property. You guys should have this first couple of sentences memorized. Unless otherwise agreed in writing, the property is sold as is. The property is sold as is in its present physical condition as of the date of acceptance, okay? So I'd say that's pretty important, right? The property is sold as is. What you see is what you get. B says it's subject to buyer's investigation, right? Okay. And then, and that's it, right? So it's contingent, it's sold as is, and the buyer gets the right to investigate. Now, we also know the seller is required to disclose known material facts and defects, right? One other thing in paragraph 11 at the beginning here, it does note the property is going to be maintained in the same condition as on the date of acceptance. So the seller can't go in there and destroy the property. And it also says that all debris and personal property not included in the sale will be removed by close of escrow. So essentially we call this broom clean, right? The property's got to be cleaned. All the crap's got to be taken out of there. Cupboards empty, drawers empty, et cetera, et cetera. Okay. So seller has an obligation to disclose material facts and defects affecting the property. They specifically point out that this includes known insurance claims within the past 5 years. Very important. Insurance companies have a database that if they see a bunch of insurance claims on a house, they may not insure that house for your new buyer. And getting insurance is a contingency of this agreement, and you need to get that done very quickly. Have your buyer get a quote right away. Okay. Now, continuing, buyer has the right to conduct investigations of the property. Based on the information discovered, the buyer can cancel, or the buyer can request the seller make repairs or take other action. Okay. So recapping, property is sold as is. The property will be kept in the same condition as of the date of acceptance. The buyer has the right to conduct investigations. The seller must disclose all known facts and defects. Based on all these investigations, the buyer can ask for repairs or other actions, price reduction, credit, et cetera, or they can cancel. Paragraph C, buyer is strongly advised to conduct investigations of the entire property in order to determine its present condition, because the seller may not be aware of all the defects affecting the property, and they may not know what's important to the buyer. So make sure you get your physical inspection. You know, guys, I can't stress this enough. You all should be doing a physical inspection on every single transaction you ever do. Now, what if the buyer doesn't want to do one? Well, I want you to think about this. Insurance, E&O insurance. Your buyers are typically not able to inspect a property with their own eyes unless they're a contractor. And even then, they may not be a specialist in anything. So you want to get somebody that knows what they're doing when they're looking at properties to point out any warning signs. If you don't have an inspection in your file and you get sued, you have to pay double your E&O insurance deductible. Okay. And that could be anywhere between $5,000 and $10,000 to protect yourself. Okay. So you guys are paying into the premiums when you close deals or monthly, but you also have a deductible if you do get sued. You know, what if the buyer won't do it? What if the buyer is going to just completely gut the place and rehab it? Just today, one of our agents called and said, I got a letter from an attorney. I sold a guy a house. I've sold him numerous homes that he's flipped over the past few years. Well, this guy's now suing our agents and the seller for not disclosing that there's a bunch of stuff wrong with the property, which the seller didn't live there. But they're also suing our agent for not insisting that we get a physical inspection, even though this person said they were going to flip the property, and they've done this numerous times. But you know what? Even if you walk a property, you can't tell what the foundation looks like. You can't tell what the roof looks like unless you go up there, right? This home said it had a roof leak, said it had $100,000 in foundation damage, right? So if you are in a deal and the buyer says, I don't want to get an inspection done, I recommend you guys pay for it yourself. Pay for it out of pocket and give them the inspection. A couple $100 on a deal that you can write off at the end of the year is nothing in the grand scheme of considering a many hundreds of thousands of dollars lawsuit against you. Okay. So with that said, let's move on. Paragraph 12, the buyer's investigation of the property and matters affecting the property. Paragraph 12A, buyer's acceptance of the condition of the property and any matters affecting the property is a contingency of this agreement. So here's where the actual contingency is put into place. And then the buyer it just goes on to talk about, you know, what they want to do. You can conduct inspections, investigations, tests, surveys, or any other studies, including but not limited to a general inspection, termite inspection, which would include wood destroying pests by a pest control company covering the main building and attached structures, may be detached, which you would need to specify. Won't test the water shower pan on upper level units in condos, et cetera, et cetera. They also say that you can inspect for lead-based paint. They talk about anything else that is noted on the buyer's inspection advisory, which is one of the last pages in our contract kind of, what do we call it, package, purchase agreement package. And there's probably 25 or 30 different inspections listed on that advisory. We'll look at that when we get down there. They have the right to review the public sex offender database. They have the right to confirm insurability of the property. They have the right to review and seek approval of leases that may need to be assumed by the buyer. Maybe you're taking a tenant on, okay? And then it says, without seller's written consent, the buyer will neither make nor cause to be made invasive or destructive buyer investigations. Meaning, the buyer can't go in there and start breaking holes into the wall to see what the plumbing looks like behind the scenes. Basically, the minimal exceptions to this would be testing by a pest control report. If you've ever seen a termite inspector walk around, they have a stick with a little poker at the end of it. They jam into the wood to see if anything is, cracking or falling apart. And then anything that's required by government or government employee, government building or zoning inspectors. Okay. B, seller will make the property available to buyer for investigations. Okay, within the time frame in 14B. The buyer will give the seller at no cost complete copies of all investigation reports obtained by the buyer. Okay, so if the buyer does any investigations, physical inspection, gets a plumber out there, does a sewer scope, they have to give all that to the seller at no cost. They're required to by law. Even after the deal, if it cancels, they still have to give anything that they had completed. Paragraph C, again, important for you guys. Remember this for your listings. Seller will have the water, gas, and electricity and all operable pilot lights on for buyer's investigations, and through the date possession is made available to the buyer. Meaning the keys, when they hand the keys over, they got to have the utilities on all the way up until that time. I see all the time where a seller will kill the utilities after the physical inspection is completed. No, it's got to be kept on the entire time. Okay. There is an indemnification clause and seller protection. So it says here, buyer will keep the property free and clear of liens, meaning they're not going to go do any sort of work or reports where somebody could put a mechanic's lien on the property. They're going to fix any damage that they do to the property through their investigations. They're going to hold the seller harmless from any resulting liability claims, demands, damages, and costs. Meaning, let's say somebody, an inspector gets hurt on the property, the buyer can't try to shift the burden of that responsibility to the seller if their inspector is harmed. Okay. The buyer will carry, or the buyer will require anyone acting on behalf of the buyer to carry liability, workers' comp, and any other applicable insurance. So any tradespeople you have out there, you better make sure they have insurance, and you better make sure it defends and protects the seller from liability to any of those people. Okay. All right, let's keep going here. Paragraph 13, title and vesting. Now we're talking about taking ownership to the property. So A says that within the time specified in 14, the buyer will be given a current preliminary title report. What is a preliminary title report? Well, it's basically a commitment to issue insurance, title insurance, so that nobody else has a claim to the property after the close of escrow. And on the prelim, it'll show any outstanding special items like, unpaid property taxes, loans, but it could also have things like judgments or, child support, spousal support, things of that nature. Okay. Also, it says here at the end, seller within 7 days will give escrow holder a completed, what's called a statement of information, a completed statement of information. Well, what is that? It's a 2-pager that basically asks for all the seller's personal information, name, date of birth, social, past 10 years of residences, past 10 years of employment. And what escrow and title do is they run this report called a general index. And what they're doing is they're looking for anything outstanding the seller may owe that would need to be paid off prior to close of escrow. Again, things like, child support, maybe in another state, things of that nature. Okay. The title is taken in its present condition, subject to all the encumbrances, easements, CC&Rs, etc. So when you see a prelim, you're going to see things on there like easements from utility companies, CC&Rs for specific neighborhoods or condos, things of that nature. But there are exceptions, monetary liens, right, of record. Again, property taxes, paid or unpaid, mortgages, judgments, anything at all. Okay. All right. And sellers are obligated to pay those off. So people will get those prelims and say, well, how do we know they're going to pay all that stuff off? Well, it says right here in a contract that they have to, and escrow and title work together to get that done prior to close. Okay. Again, within 7 days, the seller has a duty to tell the buyer about any matters affecting title that could prevent the sale, right? You know, for instance, we've seen issues where, you know, a seller is selling, buyer's buying, and then the seller conveniently forgot that they owed 80 grand to the IRS, and now all of a sudden it's a short sale, right? Well, that would be a problem. So that's why the seller has to disclose that information up front. In fact, they're supposed to do that in the listing way before we open escrow. All right. D, at close of escrow, buyer will receive a grant deed, right? That's a document that gets recorded with the county recorder's office. It's a simple one pager that's notarized that says the seller hereby grants title to the buyer, and everybody the seller signs off on that. And then it also notes here that the buyer will tell us how they're going to hold title. And there's a big old sentence in bold capital letters. The manner of taking title may have significant legal and tax consequences. Consult an appropriate professional. So what does that mean? Well, it means that the way you take ownership to a property could affect you in the future. For instance, if two people, married or not, whoever, take ownership, there's multiple ways to take title to the property. And one way, if someone were to pass away, the other owner would get the property completely. Another way that title is held, if someone were to pass away, the person who passed away, their heirs would get half of the property or whatever percentage is noted, right? So that sounds like a pretty significant legal and potentially tax consequence. So who's the appropriate professional? Well, if it's legal, you call a lawyer. If it's tax, you call a CPA. Pretty simple, okay? E just tells us what kind of title policy we're going to get, a homeowner's policy of title insurance, okay? All right, 345, let's see. There's a lot. This whole page is paragraph 14. Let's see if we can get it done in 15 minutes, okay? Guys, I will tell you, guys and gals, paragraph 14 has all the time frames that you need to consider for contingencies, removing contingencies, what happens if contingencies are not removed, and so on. So we're going to dive into this. All right, Evelyn, we should be encouraging buyer to do their own investigations as well. All investigations, yes, we should encourage the buyer numerous times to conduct as many investigations as they want. Never would you discourage somebody, and I want to just kind of bring this up. You would never say, oh, I don't think you need to get that inspection done. If a buyer says, gosh, the plumbing looks a little outdated, what do you think? You would say, you should have a plumber come out, right? Or, gosh, doesn't look like the roof is all that great. I can't quite tell though. What do you think? You should get a roofer out, right? You want to absolutely be encouraging to get as many inspections or investigations done as possible. And if you see something of concern, you need to bring it up. And by the way, bringing it up and telling the buyer, what does that mean? It means in writing. You need to have a written record of all this, okay, that you're encouraging them to go out there and get these inspections and investigations done. Hope that answers your question. If not, Evelyn, you can unmute yourself and feel free to ask. Okay, moving on. Paragraph 14, time periods, removal of contingencies, cancellation rights. The following time periods may only be extended by mutual written agreement. Mutual written agreement, okay? So what that means is you can't just extend escrow. You can't change any time frames in this contract. The buyer and the seller have to both agree. And it also goes on to state that if you're removing a contingency or canceling this escrow, it must be done in good faith. It must be done in good faith. Good faith is kind of a gray area, right? This is where a lot of lawsuits come up. What does good faith mean? I mean, it's got to mean basically that you are striving to fulfill the terms of this agreement, buyer or seller. Okay. So let's dive into this. 14A, seller has 7 days after acceptance to deliver to buyer all reports, disclosures, and information which they are responsible for. Okay. If they don't, the buyer can give a notice to perform to the seller. And if the seller still doesn't perform, the buyer can cancel the agreement. Well, we're not really doing that right now. It's hard to get a deal in the first place. The buyer is probably not going to cancel their own deal. You'll just have to work it out and try to get as much paperwork as you can out of these people. 14B, 1, buyer has 17 days after acceptance to do everything below. Complete all investigations, review all disclosures, reports, lease documents, etc., that the buyer receives from the seller, and approve all matters affecting the property. Give the seller a copy of the signed statutory disclosures in lead-based paint, okay, and whatever else they have delivered and are required to give to you. B2, within the time specified in B1, which is 17 days in this contract, which is the default, buyer may request that seller make repairs or take any other action regarding the property, and you can use the RR form, repair request for repairs. Now look at this, guys. Seller has no obligation to agree to or respond to buyer's requests, okay? The seller doesn't even need to respond to a buyer's requests. I had that happen just recently. One of our agents had a buyer. The seller said, we're not responding to your request. We have 14 backups. We told you it's as is. And so we're not even going to say no. We're just telling you we're not responding. And they were within their rights to do so. Why is that in there? It's in there because the property is sold as is, right? The buyer has the right to investigate. They can ask for whatever they want, but the property is sold as is, and the seller has no obligation to do anything at all, not even to respond. Okay, important to understand that. 14B3, buyer will deliver to seller removal of the contingency, or they'll cancel the contract. Okay. However, if any report, disclosure, or information for which seller is responsible is not delivered within the time specified, 7 days, then buyer has 5 additional days after delivery, okay, to deliver to seller a removal of the contingency or cancel. So basically, if you get something that is part of your disclosure package that the seller is supposed to give to you, after your contingencies have been removed, the buyer has an additional 5 days to remove their contingency or cancel and get their money back. Okay, and get their money back. So, even more good stuff. B4, continuation of the contingency. Even after the end of the time specified in paragraph 14B1, after 17 days, before seller cancels, if at all, okay, buyer will still have the right in writing to either remove the remaining contingencies or cancel this agreement based on the remaining contingency. Once buyer is written removal of all contingencies is delivered to seller, seller may not cancel the agreement. Okay, let me restate that. Once the buyer has removed all contingencies, the seller no longer has cancellation rights. Okay, so 2 things in that paragraph. 1, if a contingency time frame has gone beyond, the contingency is not automatically removed, passively removed. Our contract used to be that way back when I started in real estate, however long ago that was. But now it's called active removal, and that means the buyer actually has to sign a document removing the contingency. So if the 17-day comes and goes, the buyer will still have the right to cancel escrow and get their money back or remove the contingency. Okay, so that was the first part. And then again, once the buyer removes all contingency, the seller can't cancel for any reason. All right, paragraph 5, B5, 14B5, access to the property. Buyer shall have access to the property to conduct inspections for 17 days. Okay. whether or not any part of the buyer investigation contingency has been waived or removed. So this is another time frame, another paragraph in here. It says 17 days after acceptance to get into the property and do their investigations. Well, what if on day 20, the buyer wants to go back in there and take some measurements? Nope, too late. Maybe the seller will let you, but they don't have to let you. The time frame has gone beyond, okay? C, there's a box here to check for removal of contingencies. Well, what is that? Well, if you wanted to remove your contingencies with the purchase agreement, you would probably check that box. I'm going to tell you guys right now, you should never check that box. I don't see any reason why you would ever remove all your contingencies up front to buy a property. I don't care if it's cash. I don't care, right? You should still be doing your investigation, still be getting your inspection done, like I said, to protect yourself. All right, 14D, seller's right to cancel. Seller's right, if the buyer doesn't deliver to seller the removal of the contingency or a cancellation, then the seller, after delivering a notice to buyer to perform, may cancel this agreement, okay? That form gives 2 days to cancel. In that event, seller shall authorize the return of the buyer's deposits, okay? Except for any fees maybe that were incurred by the buyer, and that would kind of protect escrow basically. So seller may cancel the agreement if the buyer hasn't removed contingencies on time by delivering first a notice to perform and letting that time frame expire. Seller right to cancel buyer contract obligations. After delivering a notice to perform, the seller can cancel the agreement if the buyer hasn't completed the following: deposit funds as required, okay, putting their good faith deposit into escrow, delivering a notice of FHA or VA costs or terms, meaning if the appraiser is going to have lender required repairs, well, you need to know that within 17 days. FHA or VA required repairs, okay? That's another reason the seller can cancel. If the seller doesn't give a letter, which is a pre-approval letter, within the time specified, which you guys are probably putting your letters together with the offer, so that shouldn't be an issue. If the seller disapproves of that verification, which is certainly possible, if the in writing assume or accepts leases or liens specified. So if there's like a solar lease or one of those Hero or PACE programs, any lease or lien, if they have to accept, the buyer has to accept those within a certain amount of time. Okay, the buyer has to return the statutory disclosures, the lead-based paint disclosures in a specific amount of time. The buyer needs to sign about an increased deposits. We won't worry about that. Just know that these are all the reasons a seller can cancel if the buyer doesn't complete certain things they're required to do per the contract. The most notable ones, like I said, making lender required repair requests, putting the deposit into escrow, giving a pre-approval letter, things of that nature, okay? All right, 14E, notice to buyer or seller to perform. A notice must be in writing, must be signed by the appropriate party, and it has to give the buyer, the party, buyer or seller, at least, in this case, default is 2 days to perform, okay? So what exactly does this mean? Well, basically it means that this notice to perform has to give 2 days to do whatever is being asked, which would be things like, remove the contingency, return documents, et cetera, okay? You notice here, I changed it to 3 days. And the reason I do that is because it gives my buyer an extra day to perform. So let's say we're on our day 17 for our inspections, and I'm trying to get one last one in there, and the seller gives me a notice to perform. By having 3 days in there, I get an additional 3 days to do whatever I need to do, remove the contingency or cancel the agreement, okay? How soon can you give a notice to perform? No sooner than 2 days before the contingency expires. So if I'm a seller wanting to give the buyer a contingency removal or a notice to perform, I can't do it any sooner than the 15th day on a 17-day contingency, okay? Okay, effective buyer's removal. If the buyer removes in writing any contingency or cancellation rights, the buyer will have conclusively be deemed to have completed all their investigations and review of reports and other applicable information and disclosures, or anything that has a cancellation, right? They've elected to proceed with the transaction, and they're assuming all liability, responsibility, and expenses for repairs or corrections pertaining to that contingency or cancellation right, or even the inability to obtain financing. So once the buyer removes all their contingencies, it says we've done our investigations, we're taking the property as is, and we're assuming all future liabilities for that house. Okay. G, close of escrow. Buyer or seller may cancel this agreement if the other party doesn't close on time by first giving what's called a demand to close, form DCE. That form must be in writing, it must be signed, and it must give the party 3 days to close. Okay. So if I'm on day 30, it's a 30-day escrow. Buyer's not performing, they're not closing escrow, I can give a demand to close. If they don't close within 3 days, I can cancel the agreement. If all the contingencies are removed, the seller should have the right to retain the deposit. If they are not, the buyer should have the right to get their deposit back. You cannot give a demand to close any sooner than 3 days before the scheduled close of escrow. Okay. All right. Effective cancellation, last part of this here. It says here that the parties agree to sign mutual instructions to cancel the sale and release deposits, if any, to the party entitled to the funds. Okay. It also notes here that release of funds will require mutual signed instructions from the parties or a judicial decision or an arbitration award. So, in order to release money, everybody's got to agree. So just because a buyer or a seller cancels a contract, assuming they have the right to do so, doesn't mean those funds get released automatically. They need to have a separate written agreement. Okay. If a party refuses to cancel and release the money, well, then the party asking for cancellation and their money back would make a demand to escrow to get the deposit released to them using one of these forms: BDRD, buyer demand for release of deposit, or seller demand for release of deposit. This form here says that after 10 days, if the party refusing to give up the money doesn't dispute the cancellation, escrow should be able to release the funds to whoever's asking to cancel and get the money back. Now, practically, escrow will not do that. We will still use that form. We will still wait the 10 days before we file for mediation or have a lawyer make a phone call. But unfortunately, the contract does allow for the deposit to be released, but escrows do not do that. They actually alter that verbiage in their escrow instructions. Very last sentence, and we'll wrap up here. Parties may be subject to a civil penalty of up to $1,000 for refusal to sign cancellation instructions if there's no dispute, no good faith dispute. I use that all the time when I hear a seller not releasing their funds back to the buyer and the buyer had all their contingencies in place. We put a little letter together that says, hey, release our deposit by Friday at 5 p.m. or we're going to be seeking this $1,000 civil penalty and mediation for you to release that money. So that's usually enough incentive for the seller to come to their senses and give the money back. All right, folks, we're going to end right there, page 6 of 10. Next time we meet, we'll bang the rest of this out. Look at the last couple of advisories that come with this. 401, took a little extra time from you. Sorry about that, but that's it. Any questions? Anything I can answer for you guys? Well, you got me on the Zoom.